Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 in Jefferson County, Texas. You have been asked to come to court this morning because you have a case in this court. Your case is set on our arraignment docket. The type of case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are those cases that are commonly referred to as your more serious type of offenses. Your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious as a felony case. The case that you have in this court is a misdemeanor case. Now, your felony cases are divided into 5 categories, and your misdemeanors are divided into 3 categories. Your felony cases are divided into, it could either be a capital murder, first-degree felony, second-degree felony, third-degree felony, or state jail felony. If you are convicted of a state jail felony, the range of punishment, that is, the punishment that you can get for the offense, is a minimum of 2 years to a maximum, minimum of 6 months to a maximum of 2 years, and a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary, and a fine up to $10,000. Convicted of a second-degree felony, the range of punishment is a minimum of 2 years to a maximum of 20 years in the state penitentiary, and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 99 years to life, and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary or death by lethal injection. The case that you have in this court, which is a misdemeanor case, the misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you are convicted of a Class C misdemeanor, the range of punishment is by fine only. Now, those Class C misdemeanors are cases that are normally handled in the city court or the JP court, and the only way they get to this court is when they are appealed. When a person files an appeal, they get convicted in JP court or the municipal court, and then they file an appeal to have the case come to this court. And when it comes to this court, the range of punishment is still the same. It's by fine only. Now, if you fail to pay your fine or you fail to work off your fine by doing community service, a warrant can be issued for arrest. We call that a capious pro fine, and then you can, if you can't pay the fine off, then you can set your time out in jail to pay the fine off. The next type of misdemeanor is a Class B misdemeanor. Class B misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 6 months with 180 days in the county jail, a fine from $0 to $2,000, or you can be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to 365 days, which is a year, a fine from $0 to $4,000, or you could be given both such fine and confinement. Excuse me. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is on the clipboard that has been placed in your chairs. And the first right that I'm going to talk about is your right to have an attorney. On that first document that is titled Judge's Explanation of Rights to Defendants Without Attorney, it states that as a defendant in a criminal case, you have 3 options that's regarding your right to have an attorney. Number 1, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may waive your right to an attorney, that is, give up your right to have an attorney and represent yourself. So those are your three options. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date. It'll be rescheduled to give you time to hire your attorney. If you want an attorney and do not have enough money to hire an attorney, you would need to fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, that questionnaire is on that clipboard, is titled Jefferson County Affidavit of Indigence. If you want to waive your right to an attorney, give up your right to an attorney, and if you want to represent yourself, you may not speak to the prosecutor. The prosecutor is the assistant district attorney. We have one here in court today, Attorney Colby Hoffpower. Now, Attorney Hoffpower, you cannot speak to Attorney Hoffpower about your case unless you sign a written waiver of your right to have an attorney. Now, that written waiver should be the second page on that clipboard. And it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'll go over that with you after I finish going over this document. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, child custody, possession of a firearm, housing and public benefits, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, if you waive your right to an attorney and you want to represent yourself, you can change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document, in bold letters, it states defendant's choice. And it further states, mark initials next to only one choice. If your choice is, if you want to hire your own attorney, then you'll place your initials on the first line to the left. If you've already hired an attorney to represent you, then you'll place your initials on the second line to the left. If you want to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left. Now, once you have finished initialing one of the 5 lines, once we get to the fifth line states, if you want to waive your right to an attorney, that is, if you want to give up your right to have an attorney, and if you want to represent yourself, then you'll place your initials on the 5th line to the left. Now, once you finish initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, May 2nd of 2023. Now, for those of you who will be waiving your right to have an attorney, that is, you'll be representing yourself, you'd have to read and sign the next page. The next page states, or is titled rather, Judge's Explanation of Rights to Defendants Without Attorney. As a defendant in a criminal case, you have 3 options. Wrong. Okay, the next page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 2nd day of May of 2023 by the County Court at Law number 2 of my right to have representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge, understanding my right to have counsel appointed to me free of charge. If I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that's titled defendant, and you will date it today's date, May 2nd of 2023. Now, as a defendant in a criminal case, you have a right to have a trial by jury. For those young men are sitting in that jury box, we call it the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence, and once they listen to all of the evidence, they will retire to deliberate. And once they finish deliberating, they can either find you guilty or not guilty of the charges. You also have a right to waive or give up your right to have a trial by jury. And what I mean by that is you have a right to say, well, I don't want to have a trial by jury. And if you do so, if you waive your right to have a trial by jury, then your case will come before the judge in one of 3 ways. It can come before the judge by way of a trial without a jury. And we call that a bench trial because the judge will be listening to the evidence, and then the judge will decide whether or not you are guilty or innocent. We call that a bench trial. Now, the case can also come before the judge by way of a plea bargain, by way of an agreed plea bargain. What an agreed plea bargain is, that is, it's an agreement that you and the state, the prosecutor, have worked out to settle your case. We call that an agreed plea bargain. That plea bargain will come before the court or before the judge, and the judge will let you know whether or not the judge will follow or not follow the plea bargain agreement. If the judge does not follow the plea bargain agreement, then you can withdraw or take back your plea. The other way that your case can come before the judge is by way of an unagreed plea bargain agreement. That means that you and the state or the prosecutor have not been able to work out an agreement to settle your case, and you want your case to come before the judge for the judge to assess the punishment in your case. We call that an unagreed plea bargain agreement. Now, if the judge, if you had a plea bargain agreement, if the judge does not follow the plea bargain agreement, as I mentioned earlier, you can withdraw or take back your plea. If the judge does follow the plea bargain agreement and you want to appeal your case because you think you've been wrongly convicted or the court committed an error by convicting you, then you have to get permission from the judge to appeal your case. If the judge gives you that permission, then your case will be reviewed by a higher court than this court. That higher court is called the Ninth Court of Appeals and is located right above us, or right above this court. They will review the case to see whether or not you've been wrongfully convicted, whether or not this court committed the error by convicting you, or whether or not, those are the options that the Court of Appeals have. And then if they can either grant your appeal or deny your appeal. If they grant your appeal, then they can simply find you not guilty. They can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then your case, you can appeal it to a higher court than the Ninth Court of Appeals. And now you can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. And you would have to file what is called a pro se petition for discretionary review. I'll explain what that means. Pro se means you'll be representing yourself without an attorney. And you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not you've been wrongfully convicted, whether or not this court committed an error by convicting you, or whether or not your appeal should have been granted. If they grant your pro se petition for discretionary review, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Now, also as a defendant in a criminal case, you have a right to have witnesses to come to court to testify in your case. They sit in that chair over there. We call that the witness stand, the chair with the microphone. And what witnesses do, they can either testify for you or against you. If you're representing yourself or if you have a lawyer, they can be asked questions. We either call it direct examination or cross-examination. You can also waive or give up your right to have witnesses to come to court. What that basically means is that you will not be calling witnesses. It does not mean that the state will not be calling witnesses. They will be calling witnesses in the case against you. Now, you also have a Fifth Amendment right against self-incrimination. What that means, you have a right to remain silent. You have a right not to testify in your case. The state of Texas can't force you to testify in your case. Now, you have a right, you can waive or give up your right, your Fifth Amendment right against self-incrimination. And that simply means that you can testify, you'll be waiving your right, and you'll be giving up your right to testify, and you'll testify in your case. You also have a right to have what is called discovery. Discovery is you have a right to see the evidence that the state has against you. The evidence, it could be a videotape, it could be videotapes, audio recordings, it can be pictures, it could be witness statements, other documents, it could be instruments that the state may have that they're going to use as evidence in your case. Any evidence that they have that they're going to use in your case, you have a right to have access to that. If you're representing yourself, they'll give you access to it. If you have an attorney, your attorney will have access to it, and then your attorney can get with you and y'all can go over the evidence that the state has. Now, as a defendant in a criminal case, everyone that's here today, you have been arrested and you're out of jail. And you're out of jail on what we call a bond. There are three types of bonds. You're either out on a cash bond, which means you paid the full amount to get out of jail, or you're out on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail. Or you're out on what we call a PR bond, or personal recognizance bonds, which means that you did not have to pay any money to get out of jail. You were released under your own recognizance, which means you had a promise to appear here in court. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. For example, let's say you and the state have worked out an agreement, and the agreement is 5 days in jail. And let's say you've already spent 5 days in jail. What that means is you won't have to spend any more time in jail, because the 5 days in jail that you serve, you'll be given credit for that. And so you'll be given credit for the time that you've already served. Now, every day that you spent in jail, you get credit at $100 per day. And so if the state is offering you, well, that can go towards your fine and court costs. $100 a day can go towards your fine and court costs. So if the state is offering you a fine and court costs of $500, and you spent 5 days in jail, that means you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Now, if they're offering 7 days in jail, if they're offering 7 days or $700 fine, if they're offering a $700 fine, you spent 5 days in jail, which is $500, then you would only have to pay $200. Now, if you can't pay the $200, then we can put you on a payment plan to have you pay it off in monthly installments. But even if we do that, if you do not have an income, and if you cannot pay it off, then we can convert the fine and court costs to community service. And if it's converted to community service, you will be given $12.50 for every hour of community service that you perform. So for example, if you perform 8 hours of community service in one day, that's $100. And that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program where the district attorney's office will dismiss your case and you can get it wiped off your record. We call it expunged. You can get it erased, wiped off, or deleted from your record. And the way, in order to qualify for that program, you cannot have a criminal record, a criminal history, meaning, okay, where you have prior convictions. If this is your first time getting in trouble, then you may qualify for that program. Now, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you at getting in the program. And as I mentioned, if you get into the program, the district attorney's office will dismiss the case. And if you complete the program, it can be expunged from your record, which means erased, deleted, or wiped off. That's what expunged means. Now, if you are a veteran of any one of the branches of the United States military, the DA's office also has a program that is called Veterans Court. With Veterans Court, it works the same way as the pretrial diversion program. And the only requirement is you just have to be a veteran of any one of the branches of the United States military. And if you are, then if you get into the program and complete the program, your case can be dismissed. You can also get it expunged, erased, deleted, or wiped off from your criminal history. Now, this court, County Court at Law Number 2, has a program that I started in March of 2017 within the first 100 days of taking office. The program that I'm speaking of is the CSI program. It's normally referred, and the CSI program stands for Community Safety Initiative. It's a program that is designed to address the issue of recidivism. Recidivism basically means people committing crimes over and over. So the way we address that is through our partnerships that we have with our local agencies in the community. One of the partnerships that we have is with Spindletop Center. Spindletop Center is our local mental health center. We have Deputy Hinton, who's here from Spindletop Center. He'll come to you in a little bit and tell you more about that program. We also have Wade, who's here. He's going to come to you a little later and tell you about the Veterans Court program. But as I mentioned earlier, with that CSI program, we have a partnership with Spindletop Center. And what Spindletop will do, have private interviews, they can do an assessment, and they can develop a treatment plan for you. They can address, you don't have to be insane or incompetent to participate in the program. They will address your mental health needs. You could be a person that be simply bipolar, schizophrenic. Person could be suffering from depression, anxiety, post-traumatic stress, a whole host of other mental health needs or issues that a person may have. Spindletop can address it. They have a facility, and they have other programs as well that they can use to assist you at addressing your mental health needs. Now, if you have an issue, an addiction to drugs or alcohol, then Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery Program. And our local Alcohol and Drug Abuse Council has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and referral. With those programs are recovery programs that would help individuals who have issues with drugs and alcohol. They can do a private screening. They can do an assessment, and they can develop a treatment program either for outpatient or inpatient treatment, or they can refer you to a place in the community that can address your alcohol and drug addiction problems. Now, if you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry and the chemical industry. And also, I think Spindletop has a connections with Creative Corrections. That's also a job training and a job placement program. Now, with the CICE program, you'll be trained in the hotel industry, the shipping industry, or the chemical industry. And once you're trained in one of those areas, then they will assist you at getting the job in the area that you're trained in. If you have not graduated from high school and you would like to get your high school diploma, then the CICE program also has a GED program, Graduate Equivalency Diploma program, where you can get your high school diploma. Now, all of these programs that I mentioned to you are free. They do not cost you, it will not cost you anything. Only thing, you just take out the time from your schedule to participate in these programs. They do not cost our local Jefferson County anything as well. Now, I tell people this all the time: when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that come before this court or before this bench. And we're also trying to make a difference in the county in which we live, which is Jefferson County. And we can make a difference by producing productive people. We believe that if we produce productive people will not commit crimes because they have too much to lose. Also, we do not just give time in this court, we take our time. And we do that by not just arresting the problem, but by addressing the problem. And again, we believe that if we address those problems, we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to raise our families. So at this time, we're going to have Wade to come forward. He's with the Veterans Administration, and he can tell you a little bit about the Veterans Court program.
Good morning, everyone. Mr. Judge said, thank you, Judge.
You are.
My name is Wade Adair, I'm a veteran coordinator with Spindletop Center and Texas Veterans Commission. And if you're a veteran in here today, I'd love to talk to you about some veteran programs that Jefferson County offers. Judge mentioned veteran treatment court. If you're a veteran, I can talk to you about that. If you're not a veteran, but you have someone in your family that's a veteran or a friend that's a veteran, and they need some type of assistance, benefit, or resource in the community, please let me know today, and I'll give you my information so they can reach out or I can reach out to them. Thank you.
Thank you, Wade.
Thank you, Ron.
And at this time, we're going to have Deputy Hinton, who's going to come forward. He's going to tell you, give you some information about the program that Spindletop Center has.
Good morning. My name is Steve Hinton. I'm a licensed mental health deputy commissioned by the Sheriff's Office here. The reason Wade and I are here is because the judge has graciously invited us in his courtroom because he cares about every single person. If the judge has found it was just to prove as those who appear with legal issues commonly have mental health needs, substance use disorder, or sometimes just a lack of community resources to help you. The judge believes if he can help you with these underlying issues, we can get you out of the cycle and rest. Now, maybe this is your first time to be here, maybe it is your 10th time to be here, there's still hope. In fact, this document that I passed out to y'all when you first come in, this is separate from the court documents. This is HIPAA regulated, it will not be shared outside of your commission, but the information you place on here, contact information will give us the way to contact you and help you and advocate for you for whatever particular situation you find yourself into or whatever we can do to help you. We also have this flyer here that I want to get in everyone's hand. It tells you a little bit about the advantages of the program, but also on the front, it tells you about a 1-800 number if you ever find yourself in an unsafe place. You can get help immediately. Now, eventually the court's going to go into recess. When the court goes into recess, I will come out there. I will visit with each of y'all. I'll pick up that document from you and hand you this as well. And then we'll work on trying to contact and connect you to resources that, again, best fit your particular situation that you see the value in this. Maybe this doesn't apply to you, maybe it applies to a family member. I still like to get this information to you and work through you to help a family member who may be useful. Thank you. Thank you, Your Honor.
You're welcome. Now, ladies and gentlemen, the paperwork that you have in your hand on the clipboards, if you need some assistance, we have our court personnel who will be happy to help you to finish or to fill out that paperwork. And if you have any questions, they'll be happy to answer those questions. Now, we're gonna pick up the paperwork from you, and then once we pick up that paperwork from you, we're gonna have you to come before the bench one at a time. We're gonna go over the paperwork, and then once we do that, you'll be individually excused from the courtroom. For those of you who will be resetting your case or asking for a court-appointed attorney, we're gonna go over all of that here at the bench. And now, if you need to use the restroom, there are 2 restrooms that's right outside the door of this courtroom. The men's restroom is on this side of the courthouse, which is next to Judge Wood's court, which is right next door. The women's restroom is across the hall on the opposite side from the men's restroom. It's across the hall in front of the 172nd District Court, which is just where Judge Templeton serves as the presiding judge. Now, if you need to use the restroom, we can allow you to go out and use the restrooms, and then you could come back in. The other thing is, please do not leave the courthouse, because if you leave the courthouse before your case, before we finish with your case, a warrant can be issued for your arrest and your bond can be forfeited. Okay. So again, if you need to use the restrooms, please feel free to go use the restroom. And the other thing is, if you need assistance with your paperwork, what you're gonna do when we go into recess, just raise your hand and we'll have our court personnel to come by to assist you with that paperwork. So at this time, the court will be in recess.